All right, very good, very good. I'm going to back up just a little tiny bit. Um, I did work for the Ojibwe News Indian newspaper for quite a while too. So when I went to law school, I had a lot of the Indian questions. Problem is, you go to law school, they don't teach Indian law, they don't know the answers. So it's it's helpful, but not as helpful. I was talking with Stephen earlier there. You know, you have to go to law school and go forward at the same time with everybody and then figure out backwards where they got off track so you can explain to them and then find a professor and then the professor still doesn't really know why. So one of the early cases that I worked on was about civil forfeiture. And the case that's got a precedent is right here in Mahnomen for Morgan versus a 2000 Volkswagen. That was trying to take a vehicle away from a tribal member for maybe too many DWIs or something like that. And you can't use civil regulatory mechanisms mostly as the state, and that's what was going on. And so what I learned about that was called legal fictions. And so when Fred Morgan sued to get his car back, he had to file a case called Fred Morgan versus a 2000 Volkswagen VIN number buck 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 buck. And if it's a gun, then you have to file your name against the 3030. Or if it's money, you file the amount of money. And so you start finding out about legal fictions. That made it easier for rights of Mahnomen. The part that was hard in the beginning about rights of nature is a lot of people like to do rights of a river. That's easy to say. But think about it and come up with the answer and let me know and I'll work on it because I haven't quite figured it out. I think I'm most of the way there, but I preferred rights of fish. But the problem is fish are second, and we'll go to that. Rights of Mahnomen, when we were talking about rights of a river, Winona and I were talking, and we talked about why not rights of Mahnomen. That made perfect sense. We have a specific reservation in the 1837 treaty that says that we reserve the right to hunt, fish, and gather wild rice on the lands, rivers, and waters that we're ceding. So that was already a treaty right, and a treaty is the supreme law of the land. Wild rice was very narrow, so it wasn't like everything was wide open. And we did that with as Terry was mentioning, with the Center for Environmental Democratic Rights. And we did three things in 2018, and this is right after Standing Rock, because we were looking at Line 3 coming through and looking at Red Lake, looking at White Earth, and looking at Leech Lake, and how that was going to affect things, and even further east. And so part of what we did was, for water protection strategy, was we came up with the rights of Mahnomen off reservation and the rights of Mahnomen on reservation. And the reason that there's two of them is on reservation, the elected RBC members are the ones who are supposed to take the lead in protecting those resources. And so they have a separate and apart right as elected people on the reservation. Off reservation, really, we're all the same, unless there's a code that prevents it. And so all of us should be able to defend wild rice if we have to. And that's part of what the strategy was for the water protectors, because as part of rights of Mahnomen, State Judge Leslie Metzen, she saw to it that all of the tribal member cases, regardless of what tribe they were from, who were arrested for water protection along Line 3, were sent to tribal courts. So that was a good deal on that. And interestingly enough, my buddy Joe Plummer, who works up at Red Lake there, they didn't do a lick of work for that, but they still got all those tribal members also. So it worked out really well. The judge understood basically how our treaty rights would work and how we would have the right to protect Mahnomen because of our connection to it. So we also put together another piece which isn't talked about too much. Judge DeGroat talked about it in one of his orders, but it's the right to travel, use, and occupy. So when you talk about ancient law, we've always had the right to travel. We've always had the right to use. But even after the treaties, the federal government would refer to use and occupancy, and they would make maps of our territories and talk about use and occupancy so they could see where we were using and occupying land, which is an awful lot of almost everything that we had. So with the rights to travel, we looked at the United Nations UNDRIP for the Declaration on Indigenous People. We looked at the rights to travel itself. When I looked at Standing Rock, there were people who were charged with use of fire. And when I asked about it, they said, well, they're all in federal court. And I said, so they're all Indians? And they looked at me like, well, how would you know that? And it's like, well, that's the only ones that go to federal court out there. So they didn't even understand how to defend tribal members in North Dakota for Standing Rock in a lot of ways. And so that's what we were trying to prepare for. So when Mahnomen, they say, you shouldn't make laws that are pointed at people in particular, and we didn't. But rights in Mahnomen ended up going against the state of Minnesota, which, as said before, is one of our favorite adversaries. And so Judge DeGroat was the first judge to deal with this. But the interesting part about suing the DNR was, everybody seemed to think we were going to sue Enbridge somewhere along the line, and it ended up being the DNR because they basically gave a retroactive permit to Enbridge for the aquifer breaches and the dewatering of 5 billion gallons of water. And right now, 5 billion gallons of water, there's a lot of value to that. Whether it's stored, whether it's underground in the aquifers, whether it's in the rivers for wild rice, but they have just been releasing it because of the damages done by the directional drilling and things like that. So when we sued DNR, they were upset, of course, and they went down to federal court. I shouldn't say they went down to it, everything's electronic now. And they filed against White Earth before we even had our next meeting in tribal court, which is very disrespectful. And they not only sued the White Earth Tribal Council, but they also sued Judge DeGroat. And so Dave wanted to make sure that he recused himself from the case because he might get caught talking to a tribal council member sometime in the future. And that's when B.J. Jones came in. And basically, the old Montana, what they call the Montana test, it seemed to almost be dormant in some ways. I don't know. It's about the threats to political integrity, the economic and security, and the health and welfare. And that's what we were suing under for on and off reservation. And the DNR sued the White Earth Tribal Council and Judge DeGroat. Well, those are the people that for sure got sovereignty. The judge had to throw that out. And the DNR couldn't figure that out for themselves for a while because they said they had sovereignty and it didn't seem to stop anything for them. So sovereignty doesn't work the way they thought it would work and continued that way. One of the difficult parts was when the federal court dismissed, and that was also very pleasurable for me. When I was at the Minnesota Federal Court down in St. Paul, just looking for one of the people I thought was there. But anyway, when I was down there, the DNR was basically saying, Judge, we want you to tell Indians they can't use their tribal law against us in tribal court. And the judge looked down and said, can you point to a law that says I have that authority? And the DNR stood there quietly. There is no law that says that. And they had to go home. So they had to come back to tribal court. But unfortunately for us, our appellate court decided that there wasn't the right kind of jurisdiction. And in their initial order, they talked about what the federal courts would say. And that's not what tribal courts are supposed to do, or especially an appellate court. You should be looking at what did the tribal court judges say, were they correct, where it might be wrong, and things like that. And instead, they jumped right to essentially the end and suggested that we should have to go to federal court, just like other tribes, to have our off-reservation treaty rights acknowledged. And I would tell you that they were acknowledged in 1999 by the Supreme Court in the Mille Lacs decision. So, if you don't have people who understand treaty rights on your appellate court, it doesn't matter sometimes. And that's kind of what we ran into. And so as you go down, what was happening at the same time, and this was another pleasurable part, but a friend of mine out in Seattle, works for the Sauk Seattle tribe out there, he started looking at rights of salmon. And this was with the Skagit River. Maybe some of you saw this on different YouTube and other things. But the Skagit River has 3 hydroelectric dams on it that were put on essentially before any consultation with Indians, I think going back to 1913. And they're blocking the salmon from getting up. And it just so happened that there was a FERC renewal process going on, FERC being the Federal Energy Regulatory Commission. And, we have a treaty with the feds. They have a treaty with the feds. And so FERC said, so why don't we have fish passageways? And in a matter of about, I'm going to say 6 months, Seattle Power and Light found its way to figure out how to put fish passageways in there. And they did it because of being sued in tribal court. So there are ways to make tribal laws and tribal court work. It's just for whatever reason, it seemed to have gone dormant for a while. Maybe people didn't believe it was possible anymore. So I like the part about the salmon, and I prefer the fish. Fish are everywhere. Fish are in the water. Wild rice is great. Wild rice is in the water. But there's a whole bunch of people that don't know what wild rice is. They don't know it when they're standing by it. They don't know when it's on their plate. So we got to go to fish, is how I was looking at it originally. It's just that it was more broad when I was looking at it. Wild rice was, I think, a good catch for people in Minnesota for news and things like that about wild rice suing the DNR and so forth. But we're going to be looking at fish, and that's where I'm working forward on things. I talked a little bit about the Line 3 water protector cases that Judge Metzen dismissed. She also dismissed the last 3 cases, and in those last 3 cases, Don was one of those people. It was, for whatever reason, White Earth stopped accepting transfers to tribal court for the last 3 water protectors, and we had to fight for about a year to get them dismissed. And the funny part, of course, it's not exactly funny, but in criminal court, you can't make a motion to dismiss for your client. Duh, So this young attorney who was he representing you, Don? Yeah. And he made this plea to the judge about, in the interest of justice, that these water protector cases should be dismissed. And she wrote a very nice memorandum on that, and that she said at the end that it would be a crime to prosecute the water protectors. And this is a state judge, so you don't see this kind of stuff, but you get around us long enough and start to understand what we got going on. It changes things. A lot of those cases, not everybody went to tribal court with their cases at White Earth, but those cases were dismissed by Judge DeGroat because of treaty rights. How can you be trespassing in a place you have a right to be? And that's the premise of their things. So the rights of Monoman, I probably follow it more than other people. Sault Ste. Marie, the band of Chippewa there picked it up. So is Grand Traverse Bay. Eugene was talking about Becker County there. It has been going on for a long time with Becker County, and about a year or so ago, they had three Becker fishing cases with tribal members down in Tamarack, and it wasn't being followed up in the strictest sense, and it was Regional Native Public Defenders had it as a criminal case, and so I was one of the people that helped. CO Al Fox from here was also one of those people, and Dale Green. We went down and explained to Becker County how treaty rights work. We explained to them how the agreement that White Earth has with the U.S. Fish and Wildlife supersedes whatever the county thinks that they have. And they ended up dismissing those cases. And now just recently, the whole Tamarack Refuge has been turned over to White Earth to manage because Becker's been standing in the way of that. That's the problem, is these counties think that they have some kind of power, and they're just afraid. And Monoman is probably the most afraid. When Joe Plummer was tribal attorney here, there was a deal with trying to put the land into trust for the casino, and all the money that they had been paying to Monoman County in taxes, they were paying under protest. And when White Earth won the tax case, Monoman said, we're too broke to pay, and the federal court let him out of it. So you try to figure out, how do the laws work? I would say the laws mostly don't work. And at least, the federal and state laws for environmental protection purposes that I work with. And so you won't see me working with much of that anymore. I'm going to look a lot more to tribal courts and with tribal law. Recently, there was another case out in the Ninth Circuit with the Squamish Court. And they had this was February it came out. And in that case, it was a bunch of insurance companies that were selling specifically tailored insurance packages to Indians on that reservation and other reservations, I'm sure. And they thought that they could stay an arm's length away, but it was a consensual relationship according to the Ninth Circuit. And it didn't matter, they were non-members, and it was the first exception on the Montana test. So what you're seeing right now is tribal courts and tribal laws, they're trying to figure out how to go back to the Montana test and use that more effectively now. And I think that's what's going to happen. You're going to see that a lot more. The White Earth CAFO piece,
Could you describe a little bit more about the Montana case and so that people understand what that reference is?
Well, basically, it's a upstream, downstream water resource case with Montana. What was that? US v. Montana, 1981. And sometimes the United States comes in and helps us. Sometimes they don't. But basically, through all of the stuff that they were trying, and there was a time in the 70s that Indian tribes thought things were a lot more wide open, that we were going to be able to regulate a lot more of our resources. But it came down to that with the Montana test, the court said that we didn't have any power really over non-members in particular off reservation, and sometimes non-members on reservation. Sometimes it's a question of who owned the land. And it kind of chilled the use of that case. And so the first exception, which the one I just talked about, is consensual relationships. And so that's a lot of times if you have a business on the reservation, then they're subject to the jurisdiction of the reservation, depending upon what the issue is. And so that was the first one. But the one that really catches it all, as far as I'm concerned, for the environment, is when it threatens the political integrity of the tribe or the people. Well, that is wild rice, that is fish, that is maple syrup. You heard Eugene talking about that stuff. Those are our primary treaty foods that we reserved with the United States of America. So when you start looking at that one almost seems easier if you've already got a consensual relationship, all the vendors. That's what the case was here with White Earth, with what was that guy's name from Pennsylvania? Guido, I can't remember for sure, but it was like Guido. I just can't think of his name. But White Earth had to sue to try to, thank you, Terry. White Earth had to sue the provider for gaming here. Gaming World International is the name of the case. And again, tribal courts are being used down with the Meskwaki API. Also talked about the integrity of our resources and our health and our welfare, and it's making those connections with what we're doing that gives us a lot more power and right to do that in our own courts. It doesn't change what's going on. Even with the CAFO law, when you look at rights of monomen, or if you look at rights of fish, we would still look to CAFO and other pesticide ordinances and so forth, because really what's happening with the rights of fish, the rights of monomen, the rights of nature, when tribes are doing it, it's a mechanism to bring the issue and the case into tribal court. And you still have to use all those other kinds of laws like CAFO and so forth, but you get to slow the kind of process down sometimes. You can look at the things that are more important to the tribe. You can develop a better court record, because inevitably companies have to exhaust their administrative remedies if they're in court with us and they get to the right place. They'll be told right by the federal courts that you still have to go through and exhaust your administrative remedies in tribal court first. And that gives us an opportunity to make the kind of environmental record that we would want to go to federal court rather than the state, because that's who we always end up suing anyway. So why let the state pick and choose what's going to be said and not said and all those other things when we can do it if we go about it the right way? And that's really the way to use these kinds of tools. They're not anything bigger than that in a sense. You're just doing something there, Corey? Okay, thank you. Whew. Okay. But the thing I like about fish in particular is everybody knows what a fish looks like as opposed to wild rice. Everybody knows at least what a goldfish looks like, and everybody knows what a dead goldfish looks like, and everybody knows what 1,000 dead fish looks like. And when they see that, they don't have to be a scientist. They go, must be something wrong with that water. I should call someone. You don't even have to have it posted. It's just a no-brainer. And so that's how I'm looking at using these tools. You know, they had 800,000 fish die in a 60-mile stretch in Iowa here 2 months ago in a river. You know, I never heard another thing was even done about it. I doubt there was another thing done about it. Nobody's being held accountable. You know, so who's going to do those things? You know, and unfortunately, you know, it comes down to us a lot of times because we want those things more than those other people want them in their lives. So, you know, it's kind of a crazy deal, you know, trying to figure out how to make law work when the laws are made to permit activities and destruction of water and earth. You know, and then when you go to court, it's hard for the judge to say, well, this is what the law says. So you got to have other laws, and you got to be able to use them in a place that's more court friendly. And so that's essentially all I've done. In some ways, it seems simple, but to a lot of other attorneys, it seemed pretty miraculous at a point in time, because no one had ever seen it done. Now it's going to start happening more and more. And that's what I like about it, because the states, when we first sued the DNR, you can bet 49 other states were wondering what was going on in Minnesota. And when the salmon sued in Seattle, 48 states were really starting to wonder who was next. And that's just how it works. Because once you see that our rights have power and can work, then it's going to be used over and over. So, where are we at on time?
Plenty of time.
Plenty of time. Any questions? No questions? Oh,
There you go.
well, we got a couple in the wood now. Oh, this guy, hey.
Hey Frank, so I know that there's a tribe in Washington state that won a federal case about taxation because of their treaty right to travel. You mentioned this treaty right to travel. I'm interested, you talked about water protectors and tribal court, and how could someone be prosecuted for trespassing if they have an absolute right to travel through their own land? So I'm wondering, do you have any more thoughts about the right to travel, or is that something that maybe is not as big as fish right now?
Oh, I think it's a companion. I think it's an essential companion. It's just you might not need that until you're really into something more in court on a criminal matter. I think it's as essential as rights of fish myself. When he says tax case, you threw me off just for a little bit, but it is a tax case out in Washington. And it was one of the first cases that I learned about from my buddy who worked with the salmon to sue Seattle. And it's when I first learned about things out there. And so it's a case called Shmishkin, United States versus Shmishkin. And it was two Yakima members. It was a father-son, and they were running cigarettes from Coeur d'Alene, Idaho into Yakima, and then selling them on the reservation to everybody with no tax on them. And Washington State, just like Minnesota and everybody else, they don't like that. They want all the money they can get. And so ultimately, when they didn't get cooperation, they seized a tractor trailer full of cigarettes, or a truck full of cigarettes. And so when it went to federal court, their treaty, because of all the steep land and the mountains and the ravines, their treaty, unlike ours, because you can take a canoe everywhere, says that they have the right to bring their goods to market on the public roadways. Well, that was like wide open to the judge. It was like, so you just bring the cigarettes from Idaho over to Yakima? And it's like, well, that sounds just like what that provision in the treaty says. But Washington couldn't hear that. And they still took them all the way to the Ninth Circuit. And it ended up really that treaty provision was stronger than the Homeland Security Act, the Cigarette Contraband Trafficking Act, and Smuggling Act, because it preceded those cases by date as well as with the treaty rights. And also those cases didn't cite to Indians at the time, because a lot of times they think that they're just general application to everybody, but generally for laws to actually apply to us, they have to have some mention of the Indians that they're looking to affect. And so that case helped me understand when we had the Square Hook case here. If you remember back around 2010, there were Indians who were charged at Leech Lake, Red Lake, and White Earth, and they were netting fish on various reservations and then selling them off reservations, mostly to non-Indians. And so the DNR and the U.S. Fish and Wildlife, they spent 3 summers camping watching Indians. And finally charging them. They charged 10 originally, a lot of them from Leech Lake, but there were some from White Earth and Red Lake. And when we were down there in federal court, ultimately our treaty rights won. There was nothing in the Lacey Act that said they could even apply it to us. In fact, it said, to not disturb our treaty rights. So why would the Department of Fish and Wildlife do this if they can read those words? You have to wonder, are people just got nothing else to do? Are they mad at Indians? You got to wonder sometimes. That case I was telling you about, that Morgan case, Fred Morgan with the VW, that civil forfeiture. I figured out that civil forfeiture in law school. I was told I was wrong, but I got all the cars back after I got out of law school. But that Morgan case was a judge right here in Monoman, And what I would do is I'd have 5 or 6 orders from other judges, like in the Ninth Circuit. They'd be from Aiken County or Itasca County or someplace with a reservation or something. And I'd show them that the other judges were giving the cars back. And I think that made him madder. And so he ruled against me. And when he ruled against me, it gave me the opportunity to appeal. Because otherwise you don't get a chance to appeal and try to, set a precedent. And as soon as he realized what I was doing, then he changed his order. And I thought, what the heck? I'd never seen that before. And so when I went down to oral arguments, Chief Judge Toussaint was there. And he was talking to me about a couple of things before the case started. And I said something about the judge changing the order, to be in favor of returning the vehicle. And Toussaint said, doesn't matter. He lost jurisdiction as soon as you filed an appeal. So even the judges don't always know, just where their stuff starts and stops, but they know when they're getting close to the wrong side. And that's always helpful, at least for Judge Ondal that time. So, I look at these things as learning lessons, and it's hard because you're trying to teach people who don't want to learn, whether it's the state people, the conservation people, or whoever. And so you really have to really kind of force it on them sometimes. I was telling some folks here today that my professor in law school said all you can do is use their laws against them the best that you can and then embarrass them. And then after that, there's nothing you can do. Maybe they get away with it. And that's the other side of courts. Courts legitimize bad conduct. They follow a lot of law, but they also legitimize conduct. So I'm going to turn to another kind of a case here just recently that I've been working on. I'm trying to phase myself out. I don't think. But as I was figuring out all this stuff along these last few years, I couldn't understand how the United States could tax me federally as a person working to defend my food, my resources, my people, and all of these things. And it just didn't make sense that I should have to pay federal taxes on top of that. So I stopped. And I would write a little affidavit and say, hey man, this is what I'm doing. I live on a reservation, I live on Indian land, and I'm defending resources. And ultimately they wouldn't accept any of that. And I had to file against the IRS. And I thought I had a fairly good argument thinking about things, but when I had the first meeting with the judge and IRS DOJ attorney was there, and he started talking about this case that he had done about 3 years before. And he said, I know about Indian treaties. And I said, really? And he says, yeah. He says, they're all different. I thought, well, that's a pretty good start. It wasn't as much help as I thought, but he knew that was the start point. And as we talked about things, it was a Seneca case, and it was some gravel and things in the ground, and they were trying to tax him for, taking out the gravel and selling it. And he said in that case, and he told me about it, and then I looked at it. It said Indians became citizens in 1924, and most of us know that. But it says in tax cases, it says we became citizens in 1924, and therefore we're taxable. Now, I never heard those words in one sentence in my entire life. And so I started looking at things, and the Tax Act from 1924, there is no Tax Act. There is a Tax Act, but it doesn't have the words Indian in it. It's 102 pages. Indian isn't ever mentioned once. The case, or not the case, but the Congressional Act immediately before the 1924 Revenue Act is the Indian Citizenship Act. And basically what it says is that Indians are granted citizenship provided that, big capital letters, that it doesn't negatively impact our tribal or personal property. Now, personal property, you can check your pockets. You probably got some money in there right now. Stocks, bonds, car keys to your personal car, your house, that's all personal property. So you have to wonder, what does that mean? If you can't take that property maybe. Provided that they don't negatively impact personal property. And so for me, taxation is negatively impacting my personal property. And that's what my argument is. And in 100 years, it's never been argued. And the string of cases aren't really a string of cases like you would expect. It looks like non-Indians, IRS in particular, and some of the courts were just intent on taxing Indians. And a perfect example is the White Earth Land Recovery Project, White Earth Land Settlement Act. They took almost all the land right here through a bunch of hook and crook kind of activities. And so when you look back at the federal court system, The first case that they cite to where the Supreme Court says Indians are citizens, even though they do no other analysis, is about a 1910 Osage Indian who had a certificate of competency and was being taxed for like 1918 and 1919 and 20 tax years, 4 years before being made a citizen. So it had nothing to do with the Citizenship Act, but it was a 1931 case because things always take a long time to get someplace. And so that was the precedent for a long time. And then the precedent that the tax court cites to now is Capelman versus Squire. And Capelman was a Quinault Indian on a allotment, and the BIA said, hey, your trees are getting old, we're going to have to cut some down. And they put money in his bank, and as far as the IRS was concerned, that was income he should be taxed for, even though he didn't get the money out of the bank yet or own the land yet. And so you look at these kinds of cases and you can tell nobody cares, you know. And I had already pointed out to the IRS, and they said so in their brief, there are no treaties that have a tax exemption. Well, that's because the IRS was 50 years after the last treaty, and so we didn't know there was going to be any taxation going on. And so it's all, you know, ass backwards in a sense. And that's the way almost all of this works out with the mainstream law and Indian law. So, you know, I had an interesting oral argument here a couple of weeks ago with the Eighth Circuit, and, you know, you try to look at all these little tidbits about who your crowd is. I haven't researched everybody here yet, but, you know, maybe by tonight. So the 3-judge panel were all Republican appointees. And the lead judge, Judge Loken, he'd been on the bench for 34 years, appointed by George Bush Sr. You know, I don't know if he was a happy judge or not. I'm told that the lead judge usually is the one who has to write the opinions, and maybe he thought he was going to retire without having to do that once more. I don't know. But he was definitely on the first 2 appeals, letting people know why he thought their stuff wasn't any good, because I could tell he was going to rule against him whenever the decision came out. And he was kind of going to go that way with me too, I think, you know, in the beginning. But the interesting thing is, so you got that guy with George Bush. The other 2 appointees, Donald Trump, 2017, 2018 appointees. So on March 4th, probably everybody here heard about this, on March 4th, the Supreme Court ruled on whether or not Colorado could remove Trump from the ballot. Right. And they can't. And what they basically said, which was very simple, was that the 14th Amendment provides the opportunity for new powers for Congress to enforce the 14th Amendment provisions against states. And that it would be like, it's not the right word, but I'll say ludicrous to think that the 14th Amendment gives power to states silently. And so here's the state of Minnesota taxing Indians for income from Ohio on the Fond du Lac Reservation, and the Eighth Circuit is letting them do it. And I'm having to explain to the Eighth Circuit that the U.S. Supreme Court just overruled you. They're like, well, this isn't a tax case. I said, no, it's a 14th Amendment case. And you guys said, go ahead and let Minnesota tax the Indians when this says states don't have any powers and don't get anything from the 14th Amendment. So their analysis really, from what I could see, wasn't correct. And it took a couple of times for those judges to kind of hear that, not to mention the idea that that case talked about, there's some funny language in there, talked about this wasn't meant to make a tax exemption for Indians into the future. It was meant to protect pre-existing property rights. Tax immunity is a pre-existing property right. They're using words they don't even know what they really mean when they say it out loud. And I think the new panel that was on there could hear that a lot more easily. And it was a split decision. And in that split decision back in 2011, it was Judge Diana Murphy who was standing by herself with the other 2 guys who didn't know what they were doing. You know, and you can see that. And that's why you see her more on the lead a lot of these panels and doing things in Indian country. So, you know, you try to figure out how the law works, you try to figure out what it says, you try to figure out all the other stupid stuff, you know, and then you still miss something and maybe you don't get it right. So, but that tax case is pretty interesting, because if Congress didn't intend to tax us, you know, what happens for the last 100 years? Where's my dad's refund? Where's my grandfather's refund? Where's my refund? You know, but what's the implication to not paying in? You know, do you get Social Security? Do you get these other things? You know, so, because that's how they got their whole system set up. So you have to try to figure out where we can maybe cut back on some of that Because if they didn't make a right to tax, I think they have to give back something at some point. But you got to get a court to say that, not just Frank. But I'll say it again if you want me to. All right. Hey, any questions still?